All rise. The Court of Appeals Division 1 is now in session.
Please be seated. All right. Good morning. We are here for oral argument in UB21-0179, REILY versus ADES Paychecks. As you may know, we record and we are live streaming these proceedings, so please give your name and the name of your client when you stand up to the podium. You have a maximum of 20 minutes per side. We don't require you to use all of that time, although it's available to you. If you would like to reserve time for rebuttal, that is on you. To keep your time, it's depicted on the podium. With that, keep in mind we have studied your briefs, we've reviewed the administrative record at all levels, and we've discussed the case in conference this morning. With that, you may proceed.
Good morning. I'm Joshua Carden on behalf of the appellant Michael REILY in this case. May it please the court and Happy New Year. In denying Mr. REILY's unemployment benefits, the appeals board failed to recognize the unique time capsule that this case presents, and therefore I believe they failed to apply the remedial measure standard that this court recently reaffirmed in the Simmons versus ADES matter decided this last September. The time capsule is, and it's hard to imagine that we lived in this world at one time, but this is peak pandemic. The fear is rampant. No vaccines have been approved yet, although they're being discussed and in the works. And in the August and September timeframe, Mr. REILY's employer decides that they want to go back to business as usual. They notify Mr. REILY that he's expected to return to work in person. He manages homeowners associations. He and boards. He had been doing that remotely, according to the record, for several months. And basically asked to continue to do that, and the employer said no, business as usual. That's essentially a quote from the representative who testified at the actual hearing. Mr. REILY very respectfully said that he was concerned as an older worker, as someone.
How old was Mr. REILY at the time? 60
at the time, Your Honor. And as he knew, and again, pre-vaccination, we didn't know much, but what we did know is that older workers, in particular older people, were a significantly a greater risk of contracting COVID and dying.
At the time, in August of 2020, the CDC defined the older group as those at 65 and older. Isn't that accurate?
That's correct, Your Honor. And so, you know, it wasn't a hard and fast rule, but it was certainly stratified. But you could certainly see even then that as you got older, the risk went up.
Well, and I guess the reason I bring that up is we're looking at a case here. You know, the ALJ and the board both agreed this was a discharge.
Correct.
It wasn't a voluntary departure. So what is it that we are reviewing? Aren't we reviewing the reasonableness of the employee's conduct in refusing the order, as well as sort of the reasonableness of that order? So we're in the space of what was reasonable under conditions as they were in August of 2020. Is that accurate?
That's accurate, with the gloss that because it was a discharge, it's the employer's burden at that time to demonstrate that it was for that the discharge was for a non-disqualifying reason. So
what dispute is there in the record, or are you maintaining here as to what the employer offered to do?
The chief dispute that I can find between what the appeals board included in its order and what seemed to happen at the actual hearing was, it's you know, not to go Watergate, but what did we know and when did we know it at the time? Mr. REILY very carefully said, I went to a meeting in August. People weren't wearing masks. We're all in the same space. That alarmed me. Some people wore them, some people didn't. There didn't seem to be any rhyme or reason. And by the time of the hearing in April of 2021, the company's representative is saying, at 2 different times in the transcript, masks were encouraged, and then, they were required outside of cubicles. And she does say that in the transcript. But at the time, all the communication is in Exhibit 9 to the hearing, all the email thread. It only says encouraged. At no time does the employer ever communicate, no, there's a mask mandate. If you're going to show up, you're going to wear a mask.
Did there need to be a mask mandate?
No. And that's the other dilemma here is, this isn't a wrongful discharge case. It's not a disability case. It is a reasonableness question for someone in Mr. Riley's situation who is trying to decide if he has to choose between working in person or, at the time, the very reasonable fear that he's going to be one of the casualties or his wife is going to be one of the casualties if he contracts COVID.
This is, of course, not the scenario that we're facing here, but let's say this was a mining case.
Right.
And not COVID and none of that. And Mr. Riley reaches the age of 60 and says, I'm just too old to go down in the mines anymore. It's just not safe for me. And the mine says, well, we meet all the mining regulations. We've complied with everything that's required for OSHA and state mine inspector to meet that thing, so you've got to come into the mine. And he says, sorry, I just can't go in. I don't feel it's safe for me anymore, so you got to fire me. And so they fire him. Is that different than this?
I think it is. And the main reason is, and you didn't include this quite in the hypothetical, but implied in what I'm reading into it is the notion that says, and oh, by the way, your job requires you to go down into that mine. Like your duties lie at the bottom of that mine shaft, not up here in an office somewhere. And what we have here instead is, and this is in the transcript as well, this company shuts down, gets a PPP loan, brings employees back to work, and says, we're going to stagger the schedules and, we're going to make some adjustments here, but we want business as usual because we think it will provide better service to our customers. Not that your duties lie only in the office, is that we just want them to be. And to me, that
are we really in a position where we can second guess an employer's decision as to how they provide the best service to their customers?
No. And again, that's why I keep coming back to this isn't a wrongful termination case. This is simply a question of...
But doesn't that fit in with reasonableness? If an employer says, hey, this is my business and this is the best way for me to maintain my business, and so I'm going to require this, what authority is there for us to say, no, that's not a reasonable request?
In this case, I would say it's the employer's own admission that they allowed people to continue working from home as long as they waived a doctor's note and said, oh, you've got a doctor's note, you can continue working from home. So it wasn't a universal rule that the employer was applying at this time. They just drew lines to say, if you bring us a doctor's note, we'll give you this. And even in the department included this guidance as an appendix. On page 24, I pulled it up because it shows very clearly, look, age isn't a disability, but we need to recognize that older workers in particular...
I'm getting older and it feels like a disability sometimes.
I would stipulate to that feeling as well. That's certainly something I struggle with. But, again, and not to make light of it, again, going back to August of 2020, all we know is what is shouted at us from the news. In the context of that life, as Mr. Riley testified, was you can get this through central heat and air. The appeals board puts in there, the employer replaced the ventilation system. Except Mr. Riley testified they never communicated that. It's not in any of the emails. So that's
one of the questions I asked earlier, and
the disputes.
What is the dispute as to what they did or what they offered and what maybe Mr. Riley, I pointed at that gentleman there. I don't know if that's Mr. Riley.
That is my client, Mr. Riley.
What Mr. Riley knew or didn't know. So as I read the record, they say they replaced the ventilation system. Is that disputed?
No, they don't say when they did that. But the dispute is not that they did it or that at some point they did it. The dispute is, what did they tell Mr. Riley? Mr. Riley says, they never told us that, and no one disputes that in the hearing. No one says, oh, yes, we did. Here's the memo, or here's the email.
So he was saying that the first time he heard that was at the April hearing.
Yes. This is 8 months after he's been fired is the first time anybody says, oh, by the way, we replaced central heat and air.
And he also said that they provided staggered shifts. so that it wouldn't be not all 30 employees are coming back? Is there a dispute about that?
I don't believe there's a dispute about that. I think that's in the email thread in Exhibit 9. It may be, it's sort of ancillary. They offered him to sit in his own space. That was one.
And they also offered to let him come back on days when the fewest employees.
Fewest employees would be there.
And they were also accommodating, you don't have to come back every day. We'll agree to a staggered shift. You're working partially from home, partially here.
That is correct. That is correct. And that's why.
And finally, just to make sure.
Sure.
They did communicate to him that we'll give you a private conference room to work in. You don't have to work out in the cube farm with everybody else.
That's correct. All those things. Mr. Riley's response to that, again, under the knowledge he had at the time, was, what about central air? I'm going to be there with the circulating air with all these folks. I have to get up and use the restroom. I have to get up and go get a drink of water. I'm not going to be in a bubble. Yes, thank you, I won't be walking by. But I mean, he even talks about, there was one coworker who would walk by and cough every time he saw him. Just stuff at that time was a very.
He wasn't
weird
in
time.
the office. I'm sorry. When was this happening?
That was at the meeting at
Okay.
the August meeting that he did attend in person, and that was sort of his test run to see how is this going to look. And when he goes in and sees that the masks are rather flippant, they may be provided, but if no one's wearing them, and again. Back then, that's all we had. People were rinsing their grocery bags when they got home from the grocery store. That was not a season where we knew a lot about.
Did
how the virus was
Mr.
going.
Riley obtain any, I didn't see any, and I don't recall it in the testimony, but did he speak with any coworkers? Of course, he didn't go back to the facility, so he was unable to provide any countervailing testimony about what was actually happening post-August meeting.
Correct.
Did he obtain any affidavits or statements or casual conversations with anybody in the office to find out whether the mask wearing was improved or?
No, all that was just his communications with management. And
Okay.
in the communications with management, they're saying, yeah, we're encouraging it. We're putting him out there, but his own personal experience was not. And once again, and this was the tough part because the appeals board interpreted the record to say, oh, well, there was a mask requirement. Well, that's what, I'll say Leslie, because I can't pronounce her last name accurately, the person that Mr. Riley was communicating with testified to was at some point, well, we did mandate them. Never communicated, no policy, no memo, no email. It was always encouraged at the time when Mr. Riley was having to make his decision about what he was going to do.
Go ahead. Do you disagree that the employer put on evidence in front of the ALJ of having met the CDC guidelines?
Yes, but only in the technical sense that the CDC guidelines including making accommodations for older workers. And so to that extent.
But if the CDC guidelines defined older workers, so that was it's sort of a circular thing. If they define older workers as 65 and older, and Mr. Riley did not fall into that category, then how can we say they didn't follow even that guideline?
Now that you've said that for the second time, Your Honor, I kind of makes me want to look back at the. Yeah, see, this was, and I'll only bring this up because this was included in the department's brief. This is their appendix, page 24. The guidelines there don't contain an age requirement. It was just older workers, and they reference the ADA, which of course is 40 and older.
Right, no, I'm referring to the COVID-19 recommendations for older adults, which is a link that I believe Mr. Riley had provided at some point, and it is in there.
And there it does say 60, 65 and up. I would submit to the court that there was enough.
I guess my point is not to get too hung up on that, more so that if it was the employer's burden to establish sort of reasonableness and the evidence that they put forward, is there a piece of evidence lacking from what the ALJ received and then that the board relied on in terms of the evidence submitted showing a failure to comply with the guidelines that everyone was referring to at the time, which were the CDC guidelines?
To me, it's the additional information that the governor's executive order at the time, the ALJ put that order in place and expressly incorporated the Department of Labor guidelines as the order did. The appeals board makes no mention of the executive order in its analysis.
So what in the executive order and the letter, I guess, is there a failure of meeting the burden of proof?
In my mind, it's the language. I'm going to get to it so I can quote it more exactly. That one has more to do with the facial mask wearing, physical distancing measure, and provision of personal protective equipment. That at least is what the administrative law judge cited, not so much the older worker.
Right, but as for all of those, again, it's this sort of chain. The governor's executive order refers to the letter, which refers to the guidelines in place for mask wearing, physical distancing measures, or provision of personal protective equipment. And then we go to the CDC guidelines. And so we're back kind of where we started in terms of whether or not the employer was able to establish its burden of proof that it was complying with those guidelines.
Right, and again, to me, it was the employer picking and choosing from the guidelines. So, for example, for anyone who brought a doctor's note and said, I need to telework, they didn't put any specifics into the record, of course, but it was basically, do you have a personal health problem that you need a doctor's note for? And Mr. Riley, to his credit, looks it up and says, no, I'm just older. I'm healthy otherwise, but I'm older and I'm in the increasingly, headed towards the high risk category, and I'm already in an increased risk category.
So your argument is because the employer allowed some exceptions, they must allow all exceptions? Isn't that kind of a no good deed goes unpunished argument?
No, it's not a question of must, Your Honor, and that's why I keep having to keep, because I do more employment law than unemployment law, so I have to keep coming back to the fact that I'm not making the argument that the employer was not allowed to discharge Mr. Riley under these circumstances. The question is, have they shown, is it, it's a disqualifying reason? Was he being insubordinate for saying, I don't want to die, and I think if I come to work, I might? And you're letting other people work remotely. You've let me work remotely. This is essentially that new assignment type of language.
And I kind of get, and I realize this is not a PUA case,
Correct.
Isn't that what PUA is for? I mean, your argument would seem to be, especially since he didn't meet apparently the 65 requirement, that anybody who expressed fear can just say, I'm not going to come back to my job. Doesn't that fear have to be a reasonable fear?
It does. It does have to be a reasonable fear. And Simmons,
Isn't it what the employer did, kind of a reasonable accommodation? We'll give you all this, and if you get us a note that's saying it's something to show it's a reasonable fear, we'll accommodate that.
I don't think it can be, because they didn't say we'll give you all this. They said we'll put you. They never addressed his central air conditioning concern. Apparently they did.
We'll give you some things, but you acknowledge there was at least some things there.
Right, but in his mind, if he's in that building, he is in the circulating germs in the central heat and air. They never say a word about that. They never say, oh, well, we're going to fix that, or we've replaced that. They never give him a reason to overcome that central fear, which is, it doesn't matter if I'm in my own office or not unless you shut off the heat and air to the building. No one ever addresses that. And Simmons is a PUA case, but this court actually cites some of the regulations and, is basically saying, look, a reasonable worker is not going to leave impulsively. He's going to try to adjust unsatisfactory working conditions. And I think, again, that's this court citing as persuasive authority the Arizona regulations related to an employee who just up and quits. And this is not a quit situation. Mr. Riley wanted to keep his job. He was, to all intent and purposes, a good employee. He'd been there for years and was afraid, as many were in that season, of there being no vaccine and an employer who seemed to not be taking the disease seriously enough, except if you could provide a doctor's note. Under all those circumstances, and again, given the remedial measure standard that this court applies, I'm arguing that Mr. Riley was 100% reasonable in saying, I can't come back to work in this environment at this time. If it had been 4 months later, as we know, Pfizer got emergency use authorization. He could have gotten a vaccine, end of problem. But that's why this case is a unique time capsule of life under COVID, and we would ask that the court grant Mr. Riley his unemployment benefits. I'm going to save my last minute and a half, if I may. Thank you.
Thank you.
Good morning, and may it please the court. My name is Emily Stokes, and I represent the Department of Economic Security in this matter. We're here today not simply because of the COVID-19 pandemic, but because Mr. Riley did refuse to comply with a reasonable order given by his employer. And even though the COVID-19 pandemic, it did present some unique challenges, the basic tenets of unemployment security law, they still do apply in this case. And in Arizona, if a person is discharged for misconduct in connection with their employment, they are disqualified from receiving benefits. That was true before COVID, during COVID, and after. Now, the issue in this case, as the court and counsel have both identified, it is whether Riley's decision not to come into the office place was reasonable. He's asked this court to find that it was, but his argument is actually a very narrow one. He's argued that the workplace was unsafe, but his argument and his brief focuses entirely on Vision's mask policy. He doesn't challenge any other aspect like social distancing or anything like that. He really focuses narrowly on the mask policy. And he uses the CDC guidelines as his benchmark, his measuring stick. But what's interesting about the CDC guidelines is that they recommended that employers encourage their employees to wear masks. That's what they recommended at the time, and he knew that because he actually submitted a copy of the guidelines to his employer when they were talking about coming back to work. So he knew what the guidelines were, that employees were encouraged to wear masks in the workplace.
Why does the employer seem to be so concerned about making sure that it was mandatory, at least in some respects, like when you're not in your cubicle?
Well, I think in this case, the employer was trying to go above the guidelines.
But that would be in April of 2021 when it's like, I mean, was there any indication prior to April of 2021 that there was this mandatory requirement that was conveyed to Mr. Riley?
No. The email that Mr. Riley received, what it said is that employees would be encouraged to wear masks in the workplace. It didn't specifically say that they would be required. Mr. Olshagan did testify that actually once they did return to the office, masks were in fact required. But what's interesting again about the email is, according to Mr. Riley, what made the mask policy deficient is that it didn't follow CDC guidelines, but it did follow CDC guidelines. Even if all he knew was that email, the email said that masks would be encouraged in the workplace, and that's what the CDC guidelines recommended at the time. So even just looking to the email, his belief that the mask policy was deficient was not reasonable.
Okay, what about the fact that he goes to this meeting in early August? Was there any kind of mask policy in place at that time?
I can't really speak to that. The record isn't entirely clear. It seems in Riley's testimony, he suggests that people were supposed to be wearing masks, but not everyone was. But I do think that early August meeting.
So why can't that frame the basis of where he's coming from when 2 weeks later, or less than 2 weeks later, he receives an email saying, everyone will return to the office immediately, or by September 1st, whatever. Why isn't that a reasonable fear?
Because the email documents that once the workplace was going to open, the conditions were going to be so much different than what was at that meeting that a lot of the fears and a lot of what he knew about what made that meeting dangerous were going to be alleviated once the mask.
Explain to me how that was conveyed to him. It would only have been conveyed through email, correct?
It appears, based on this record, it appears it was an email conversation between Mr. Riley and the employer.
And what in those emails conveys that it would be substantially different than what it was when he attended the conference meeting in early August?
Because the email shows that Vision was taking very serious steps to make the workplace safer by staggering the employee schedules, supplying all sorts of materials, masks and hand sanitizer.
What about converting the building, the air conditioning and heating?
The email didn't state that, no, but it did mention that they were going to keep the public out, they were going to take measures to make sure there weren't as many people in the office.
But the employer was on notice, were they not, that he was concerned about that, the passing of germs through the air system, and that appears to be like a legitimate concern of the CDC as well.
And they told him that they were in fact following CDC guidelines. He emailed them to ask, are you following these? And they said yes. And the record does show that it did take reasonable steps to follow the guidelines. But again, in the actual briefing, the real thing that he really focuses in on is the masks. At the hearing, he focused in somewhat on the air, but the big thing was that the
Are you
mask-
suggesting that's waiver? I mean, of the
I'm suggesting that it's a very
ventilation
narrow-
issue? Because,
sorry.
no, go ahead.
I'm suggesting it is a very narrow issue. What he has argued is that the workplace was unsafe because Vision was not following the mask policy, and that simply is not true. Even by his version of events, it was. But beyond that, the board actually did find that Vision went above the CDC's guidance, that it was in fact requiring people to wear their masks when they left their offices. And that finding is supported by a reasonable interpretation of this record and substantial evidence, which is the standard of review in this case. It is supported by Ms. Drolshagen's testimony. She testified to the policy. She also testified that because she was actually going into the office, people were in fact following this policy and were wearing their masks. The best Riley could do was speculate.
She didn't specify that that was the last 2 weeks of August, did she?
She was asked if people were following the mask policy,
Well, I mean,
and she said
that's a
in
pretty
her...
broad question, being 6 months later.
I can only look at this record, but based on this record, that's how she answered the question, was that in her experience, people were following the mask policy. And so based on a reasonable interpretation of this record, it supports the board's finding that masks were required when people were outside of their offices and cubicles. And again, because of the standard of review, we believe this court should affirm that finding of fact. And if it does, that in fact refutes Riley's claim that the board or that the Vision did not have a CDC compliant mask policy.
I have a procedural question for you.
Yes.
Does the record indicate, or maybe you know from your personal experience, would the board have listened to the recording here, or would it have had a transcript provided? I noticed in the statute, I learned something, try to learn something new every day, but unfortunately I have to relearn some things. I noticed that the statute says that the board is supposed to be provided a transcript, which I don't think that ever happens in my experience. But I'm wondering if the record indicates that the board listened to a recording of this hearing.
I don't know. I don't think the record does show that.
Because I think that the appellant has raised this, how could the board possibly find that Poyer credibly testified without hearing the tape?
Well, one way to assess witness credibility is to hear things like tone of voice, but another way is just to look at the basis of their knowledge. And so the board, in looking at Drolshagen's basis of knowledge, that she testified from her own personal experience that people were in fact wearing their masks in the office, that's what made hers more credible over Riley's speculation.
So can't we, the three of us, do the same thing that the board did? But then if they're reading a cold record, don't we read a cold record in the same fashion?
Yes, but the statutes and this court have held that the board does have the right to make its own findings of fact and to make contrary findings of fact even to the ALJ. The board does have some greater authority when it is reviewing its decisions than a court typically does on judicial review. But even, again, keeping that issue of credibility in mind, these credibility determinations that the board made are the things that are apparent from a cold record, which is that Riley only provided his speculative evidence, whereas Ms. Drolshagen actually testified from some personal experience.
I know that your colleague suggested there was a dispute as to whether or not Mr. Riley had been made aware of the ventilation. Do you have any response to that?
Again, I can only look at the record, and the emails themselves don't specifically mention the ventilation system. They do mention that they're complying with CDC guidelines, and again, Ms. Drolshagen at least testified at the hearing that the ventilation system had been improved. There is nothing in this record to show that that exact information was communicated to him.
Nor does the record indicate when that system was upgraded.
To the best of my recollection, I don't remember exactly if Ms. Drolshagen, I think a reasonable interpretation is that it was installed, that it was improved before the office opened, but I'm not sure the record is 100% clear on that.
I'm sure you know the record better than I do. I will obviously have to go back and double check all this, but I thought I recalled that there was some emails that he either replied to or responded that referenced the ventilation upgrades, so that he had replied in some way that he got some indication from the email that they were doing these, maybe not that they had been done, but that was their plan, and he replied to those. Is that not accurate?
To be honest, I apologize that I think my recollection of the record, I'm just not remembering. So that may be correct. Unfortunately, I just can't say either way, and I apologize for that. I do want to address some of Riley's specific contentions as well. So he has, in general, well, he addressed the Simmons case that this court recently issued. Simmons is similar in that it involves employees who feel that the workplace was unsafe and either quit or decided not to go back to work. The vast difference between Simmons and this is that in Simmons, the employee is the only person who testified. There was no contradictory evidence, and there was no finding by the ALJ that his testimony was incredible. That's a vastly different record than what we have here, where an employer did testify.
Does it matter that Simmons is a PUA case and this isn't?
I think it's instructive. Because it is a PUA case, it involves different eligibility grounds, but to the extent, if we're talking about proof, the kinds of proof that would need to be given to establish that a workplace is unsafe, I think it's at least instructive. And since counsel did mention it, I just wanted to point out the ways in which Simmons is quite different. The record in Simmons is quite different from this case, because here we did have contradictory evidence. We did have a finding that at least Riley's testimony was not persuasive, and so it's vastly different.
Your colleague had also leaned on the exceptions, the two other employees that had the exemptions, and the board did make one of the additional findings related to those.
Yes.
Do we have any information in the record? I didn't note any, but is there something that maybe I missed that gives us the specifics as to those two employees, what their accommodation was based on, or?
Ms. Drolshagen, all she mentioned was that two employees gave notes saying that they couldn't go into the office until some sort of date certain, and so they were allowing them to work from home until some date certain. It did not appear to be a permanent accommodation. It appeared to be a somewhat temporary one. And the board's consideration of that, I think, was relevant because, it is looking to the Department of Labor for some guidance as to what it needs to do during COVID. And in the PUA program, there is an eligibility ground if you cannot reach your place of employment because a doctor has told you to quarantine. And so I think it was reasonable for the board to at least consider whether or not Mr. Riley did have some reason medically why he could not make it to the office place. I don't think it shows that somehow Vision was being capricious and deciding to give an accommodation to someone who truly showed that they need one versus Riley, who hasn't shown truly based on his age or his health that he really needed one. I think on the contrary, it just shows the Vision was trying to work with him as best as it could. They didn't reach an accommodation that he wanted, but that doesn't mean that Vision did not provide a safe workplace. On that same note, Mr. Riley seems to believe that because he's over 60, he was entitled to a teleworking option, especially because he had been teleworking. But there's nothing in the guidelines that make that so. Just because he's of an advanced age doesn't mean Vision had to give him a teleworking option. Even in ADA cases, which this is not, but even in an ADA case, an employer would not be required to give their employee a teleworking accommodation if other accommodations could be reached. And so he has cited no support for the idea that Vision was required to allow him to telework simply because he believed it was the better option for him. Additionally, Mr. Riley has argued that Vision was not in fact required to prove a business necessity in order to give its order, and yet at the same time he is suggesting that this court and the board should have weighed his desire to telework versus Vision's desire to bring people into work. And he's arguing that business as usual isn't a good enough reason. But again, he's offered no actual authority to support that position. Implicit in the employment relationship is that employers get to set the place of work. And
is there authority for that? I mean, that's probably a dumb question, but I mean, is there authority saying?
Well, the department's
employers?
regulations, there is a regulation. It says implicit in the work relationship is the duty of the employee to report for work and remain at work in accordance with the reasonable requirements of his employer. So there is some, at least in the department's regulations, they do consider that to be implicit within the work relationship. And
At work, of course, in the new economy that we live in, has taken on a whole new meaning post-COVID, hasn't it?
it has. But, well, in general, some standards have changed, but that standard remains the same. The employer has the right to insist that people come to work and work in the workplace. There's nothing in the law that suggests that it has to prove some extra special reason why people should go to a specific workplace to work.
The employer has the right to insist upon that as long as it takes reasonable precautions to protect the health of its workers, correct?
Right, and again, in this case, the main thing that REILY has claimed is that the mask policy didn't comply with CDC standards, and that's simply not what this record shows. So he still hasn't actually proven his case that it was an unreasonable order or that he acted reasonably in refusing to come to the workplace. Just as a final matter, Mr. Reilly did raise for the first time in his reply brief that the executive order of the governor somehow compels the department to give him, to qualify him for benefits. My first argument is because he's only raised that in his reply brief for the first time, that argument is waived. But even looking, issue of waiver aside, looking at the executive order, that's simply not what it requires. It gives the Department of Economic Security the ability to create some standards as long as they are informed by the Department of Labor. And the Department of Labor has made it clear that a person may be justified in leaving their workplace if it's not meeting state, local, or national health and safety guidelines. In this case, Reilly has never identified a state or a local guideline that Vision was not complying with. And other than the mask policy, he's never identified any other aspect of the work site that was unsafe. All he's addressed is the mask policy, and as I've mentioned a few times now, the board's finding that masks were required in the workplace was supported by a reasonable interpretation of the record. And even if we were to accept Reilly's version of events as true, he hasn't shown that the policy was not in compliance with CDC guidelines.
Well, he has shown, that, at least so far, and we're going to go check the record, but that there's no indication that ventilation system conversion was conveyed to him before he was fired.
I agree, but another thing that's important,
Do you agree?
well, I'm sorry, there's some dispute in the record on that, and I want to be clear about that, and thank you for reminding me. I would need to go check the record again, and I do apologize for that. But what I would also then emphasize is that the CDC guidelines are a series of measures and controls meant to be placed in combination for employers to use to make the environment more safe. It's never expected that an employer would put every single guideline into effect. When you read the guidelines, it shows that the measures are a series of different measures that can be placed in various combinations to make the workplace safe.
Sure, nor are they exhaustive either. I mean, they don't cover the entire universe of what an employer should do during a pandemic, do they?
No, I don't believe they do.
Yeah.
But again, the only thing that Reilly has brought up in this case is the mask policy. And so with the mask policy, he has failed to show that it did not comply with CDC guidelines. And so limiting it to that narrow issue, he has not made his case. If there aren't any other questions. In conclusion, the department would ask the court to affirm the board's decision that Mr. Reilly is disqualified from benefits. Again, this record, it reasonably supports a conclusion that he defied a reasonable order given by his employer when he decided not to go into the workplace. Thank you.
Thank you,
Thank you.
Counsel.
Briefly on rebuttal, Your Honors, I did have the benefit of a 19-minute break, and on IR1, pages 27 and 28, Mr. Reilly says, I didn't know they'd made an improvement to the ventilation system. They didn't tell anybody that I know of. So that's my record site for the testimony. At no-
Counsel, looking at the emails on August 18th, Vision says Vision is taking all precautions they can and following the CDC guidelines. That same day, Mr. Riley responded, pasting in the summary of changes to the guidelines, which among other things specifically listed improving the building ventilation system.
Correct.
And in response to that email, the HR says they are following the CDC guidelines. Now, the employer does not ever, as far as we can tell, explicitly point out the ventilation system.
Right.
But in that exchange, isn't there at least some reasonable reading to say that the employer was suggesting following that guideline, since Mr. Riley is the one who identified it, and they said, yes, we're following the CDC guidelines?
Sure. I guess the difficulty there is the rest of the thread, the employer says, and how they're actually doing that is you can have your own office, or you can give us a doctor's note. They say we're following them, because what else does an HR person want to say? Oh, of course we're following them. We're following all the rules.
We are, though, here on appeal based on your brief, which did not raise the ventilation issue. So that is a point, and it was raised at the ALJ proceeding.
It was.
And there was testimony before the ALJ, and reading that testimony now, if I can find the context of the judge's question to Ms. Drolshagen was, with the employees coming back into the office, were there certain measures that the company took in order to keep the workplace a safe environment for the employee? She testifies yes, and we had replaced the ventilation systems. So whether or not he was on notice may go to his reasonableness. We'll have to think about that.
Right.
You didn't argue that on appeal.
I did not put that in
The ALJ had evidence before it to determine that the employer had taken reasonable steps. The board affirmed those findings, and it's our job to look at the record to see if there's evidence in the record to support what the board determined. Is that an inaccurate statement of our job?
Not quite. The only thing I would gloss on that is to say what the appeals board found was they did change the ventilation system. That's not the only relevant question, is how would Mr. Riley have been able to factor that into his decision when there is no dispute in the record that he was never informed of that fact. So in making Mr. Riley's decision as to whether he's going to refuse work, and I realize I'm way over time here, but the statute says we're going to look at the degree of risk involved to his health and safety. And that's...
But do we look at his subjective perspective on that, or do we look at the objective metrics that we had at the time, which are things like the CDC guidelines?
I think it's both. It's the subjective, but it's premised on the objective as to what's actually factoring into his decision. If they had said, we've required masks, not encouraged them, we've required masks, we've replaced the ventilation system, what's your excuse now? That's an objective communication that we can then look at. We don't have that. All we have is the subjective at some point.
Thank you, counsel.
Thank you.
Thank you for the arguments. We'll take the matter under advisement, issue our decision in due course. We will go into recess to reset for the next argument.